ठीक है सर, ठीक है। ये ऑन तो हो गई मीटिंग क्योंकि
Hello, hello, hello. Hi, Nidhi ma'am. Can you please check whether your camera and mic is okay?
Hi, Harshad and Harsh. Thanks for joining. Can I just confirm if I'm audible?
Hi, Tana. Yes, I can hear you. Thank you.
Hi, Tanay. I can hear you as well.
Yeah.
And
I would just
I,
request if you all could test your cameras, and if you're open, we can proceed with the webinar at about 4:30.
great. I think my
Yeah.
camera is fine.
Yeah, that's great. We can proceed with the webinar at 4:30. You may. Thank you.
Hi, Harsh. Nice to meet you, man.
Nice to meet you, Harshad. Nice to meet you. Yeah, we'll dial back in 12 minutes. Thank you.
Yes. See you. Bye.
Hi everyone, Tanaya from CADR. We will start the meeting, the webinar in roughly 5 minutes once all the speakers have joined. Look forward to the webinar.
Hello. Good afternoon, Gauhar. Hi, Harshad.
Hi, hello.
Right. I think probably everyone has joined. Harish had joined, and I think then he got disconnected. Yeah, Harsh is here back. Hello, Harsh. Yeah.
Hi, Lakshmi, how are you?
And Tarun, Justice Geeta Mittal's office, she told me that she'll be joining a little late. So I think we can
All right.
start without waiting for her. So she had said that she will join somewhere in between.
We can start now.
Yeah, I think Mehak has also joined. Yeah, Mehak. Hello, Mehak. Okay, her name is there, so she has joined.
we'll just begin. Good afternoon, everyone. I hope I'm audible. On behalf of the Center for ADR at National University Delhi, I am delighted to welcome all of you and thank you for taking the time to join us in today's webinar. My name is Tarun and I am one of the student coordinators for the center. The Center for ADR at NLU Delhi has a vision to promote the use of ADR methods among legal and non-legal professionals and students. The aim of the center is to foster discussions and conduct research on contemporary issues in arbitration and other ADR methods. This webinar today is a third edition to the CDR webinar series. Today, we are honored to have with us a distinguished panel of experts who bring a wealth of experience and knowledge in arbitration. For the convenience of all the participants and in the interest of time, we have sent the panelist briefs to all the registered participants. However, I will quickly introduce the panelists for today's webinar. It is with great honor that I introduce the first panelist for today's webinar, who will be with us in some time, Honorable Ms. Justice Geeta Mittal. Justice Mittal is the former Chief Justice of the Jammu and Kashmir High Court and holds the distinction of being the first woman to hold that position. Justice Mittal is the first woman from the field of law and justice to be conferred the Nari Shakti Puraskar, which is India's highest civilian honor for women. We have with us Mr. Harshad Pathak, whose areas of practice and research include international commercial arbitration, investor-state dispute settlement, and public international law. He works as a consultant with Mayor Brown, Paris, where he represents foreign investors and states in investor-state disputes. We also have with us Ms. Mehak Oberoi. Ms. Oberoi is the General Counsel for GE Vernova with over 17 years of experience. She has authored pieces and has delivered talks on arbitration and mediation. Next, we have with us Mr. Gauhar Mirza, who is a partner at Cyril Amarchand Mangaldas and has represented both public and private corporations in ad hoc and international arbitrations in matters of infrastructure, real estate, etc. We have with us Mr. Tariq Khan as well, who is currently serving as the registrar of the IAMC Hyderabad with over a decade of practice before various high courts and the Supreme Court of India. Mr. Khan is a seasoned advocate specializing in commercial litigation and arbitration. We also have with us Mr. Harsh Hariharan, who is a senior advocate and senior associate at the Ashurst London office. He specializes in international commercial arbitration and investment treaty disputes and has experience of both ad hoc and institutional arbitration. Now, I would like to pass it back to Dr. Nidhi Gupta, who has generously agreed to moderate the session. Dr. Gupta is an associate professor at NLU Delhi and is also the faculty coordinator of the CADR. And before we begin, just a short note for all the participants. If you have any questions that you wish to address to our panelists, I request you to please drop them in the chat box and we'll address them towards the end of the session. The chat box is currently disabled, so we request you to please note your queries and ask them when we reopen the chat box during the Q&A session. Over to you, Dr. Gupta.
Great. Thank you, Tarun. So once again, a very hearty welcome to all of you and really heartfelt gratitude for agreeing to do this in such a short time. It was really a short notice, Harshad, really last minute notice. And we needed to do it because, as you all know, the last date for submission of comments is like 3rd November, and then Diwali break is like commencing the day after tomorrow. For us also, it is starting from Wednesday. So we really needed to do it just before that. So that is why all the rush had to happen. But I'm really happy that it was possible. And I have to be thankful. I'm really, really thankful to Gauhar, who actually made it possible. He made it happen, like putting all these, helped me with all the panelists to come together. It is such a short notice to be able to discuss this. Also, I'm really happy that also we have been able to make the panel representative. So Gauhar, thanks a lot for that right in the beginning, right at the outset. Taking on, of course, as the title says, we have to discuss the amendment bill, the draft amendment bill 2024, which seeks to bring in certain changes in the 1996 Act. And of course, like as it happens with any amendment bill, it brings in various categories of changes. So also in this bill, we see like 2-3 kinds of categories. So some are like maybe much awaited, which were like already introduced by either 246 Law Commission or by HLC or by now by Vishwanath Committee report. So some of them are in that category. So maybe like if I just name one or two in that category, emergency arbitration is one, which was recommended for a long time and is now been statutorily recognized. Then change in section 20 relating to place, seat, venue, that was also like one of that category. So there are like, these are a few changes which were probably, we can always debate on that too, but then these were some, especially emergency arbitration. But still one would say that these are the changes which were like kind of much awaited. Some are like minor tinkering in the sense, positive changes like adding limitation periods in certain sections, which I think also very useful. But I thought for this webinar, as I also discussed with all of you over email, that we could probably look in 3-4 major amendments which like kind of have a potential of changing the landscape, or which seem to be like hitting in a very significant way at the arbitration regime in India. And those identified amendments that we can discuss over next 60, 75 minutes would be like most important. That's according to me. Of course, we will be able to take up other things too. But according to me, like the most significant changes appear to be addition of section 2A, because it's like introduces, gives statutory recognition to seat. Then another is deletion of 9 clause 3, which is also a very, very major change, which the Act is proposing after presuming that all the jurisprudence was settled in that after ArcelorMittal. Then we have another addition, which also is like really, really big change of adding appellate tribunals in section 34. There are many other changes, many like kind of reorganization of section 34. But apart from that, a very major change in section 34 is like addition of appellate tribunal. And then the last, probably we can say, of course, introduction of counsel and arbitration counsel, which also needs probably a larger discussion. Maybe we won't be able to address it systematically here. And then, maybe one more change that we would be able to discuss, because this Act proposes to give to effect what was proposed in 2019, that is deletion of 11.6A. So with the idea of giving more importance to institutional arbitration. So I think largely we'll stick to that, and then maybe we'll have time, and then probably we can talk about anything which to any one of you feels more pertinent or needs to be highlighted. Maybe we can take that up. So I think we can start with like if we go in a sequence, maybe we can start with section 2A, which introduces concept of, or gives statutory recognition to concept of seat, saying that it removes the definition of court in 2(1)(e), and it makes 3 kinds of now categories, which is like the courts where the seat is either chosen by the parties or determined by the tribunal. And then it also says in all other cases, emphasizing that there would be some cases where seat will remain undetermined. And then it also proposes deletion of 42 because it's like removing 2(1)(e) and thinking that 41 goes with it. So I have some very, very fundamental questions, and I have been arguing this for a pretty long time, that do we really need to introduce concept of seat in domestic arbitration? So that's like one fundamental question that I had. For the moment, I'm using the word domestic arbitration, but maybe we can use a more comprehensive India-seated arbitration, which includes both domestic and ICA. And for me, a question is, does it not enhance or gives more possibilities of litigation, bringing in this whole seat venue debate in domestic arbitration rather than, so jurisdictional battles might be increased. Will this result into increasing battles for jurisdiction? So if at all, first of all, do we need to introduce this concept, right? So concept of seat. And of course, when we also adding now, this amendment is also adding this audio-visual means. And then it says that this idea of seat will be mutatis mutandis applicable in audio-visual means. So I think that adds another layer of complication or complexity. So with this, I would say that the fundamental question is, do we really need to add this concept? And then second, if at all we agree on that and we say, okay, there would be some cases where the seat remains undetermined, So then do we really need to omit section 42? Don't we need to retain section 42 if we are envisaging in other cases? So I think to begin with, probably I can just start with Gohar having really into Indian practice, and if we can, and then we'll move on with that. Yeah.
Thank you, Dr. Nidhi, and thank you everyone for joining this important panel, because it's just 3rd November that everyone has to give their suggestions on the proposed bill, and I think the time is absolutely right. And I think most of the discussion that Dr. Nidhi has already done about what has been introduced and what has been proposed to be introduced in the bill with respect to 2A, deletion of 42, and what 2A brings in. And the question, therefore, is whether it is correct or incorrect. The answer can be twofold. One, yes, it is correct, because we have been seeing from the days of Roger Shashua and then Balco, and then again and again that reiteration of the issue of seat versus venue versus place. It has been lawyer's paradise, obviously, as we will all will agree, Harsha, Tarek, we are all practitioners, and we all agree that it has been a lawyer's paradise to keep arguing and keep giving new interpretations to whether its seat should be the determinative factor, or it should it be the venue to be the determinative factor. I think the legislature has finally come to a point where they have to just give a guiding light towards seat, and then you please follow it. It's like the amendment that the way it has been brought in is to just show that it will only be seat, and other factors, like for example, Dr. Nidhi said that where the seat is not determined under the agreement, then what happens, and whether deletion of 42 then becomes a problem. According to me, yes. In the second factor, where there is no determination or defined seat, there can be a problem in deletion of 42, because 42 otherwise becomes a court where everything should follow ideally. But now after deletion, we'll have to again see, and whether it becomes again a question of interpretation, whether seat will again become a question of argument before court, whether there'll be more Roger Shashuas, Valcos, etc., etc. I think time will tell. But I think as a practitioner, I see it as a positive step. At least I see a guiding factor right now. That, okay, today if I have to draft an agreement, and we have to always understand that arbitration doesn't mean only arbitration. When the dispute arises, we have to also see from the point where we draft the agreement. I think the indication of legislature more is towards putting these things clearly in your agreement, so that tomorrow when it comes to court or it comes to an arbitration and there is a requirement of interpretation, the interpretation is reduced. I think that's the idea. And we, of course, with time will realize whether or not it becomes effective so as to reduce the possibility of fights that happen in courts at the stage of 11, whether it happens at the stage of 34, 9 in the domestic contour, obviously. But I think it's a positive step, and we should look at it as a positive step and a determinative step, so to say.
Yeah, thank you, Harshit. Like if you would also want to maybe add or say something in addition, apart from this.
Yeah. Well, I mean, I echo everything that Gohar said. Firstly, thank you for having me here, and it's great to reconnect with some old friends as well this way. I echo what Gohar said in terms of what is the indication to the parties. I'll only add that the amendment also appears to give an indication to the arbitral tribunal. There is a big difference between how sometimes arbitration proceedings are conducted either in India or outside. And one of those fundamental differences is that at the beginning of an arbitration, in non-Indian arbitrations, you will always have a tribunal clarifying what is a procedural order number one. And one of the things that it will clarify is that ideally with the consent of the parties, but if not, then the tribunal will decide after listening to arguments that this is the seat. So there may be an indication to the tribunals in India as well, but some of them do it, some of them don't do it, but to adopt some of these best practices and say, see, seat is an important thing in domestic arbitrations now. So at the very beginning of the arbitration, you need to provide clarity from that. Because what we already have, I mean, coming to Dr. Nidhi, the point you mentioned, what about situations in which maybe the seat is left undetermined? It may happen in the beginning or during the course of the arbitration, but if you look at section 31(4), the existing one, but also the proposed one, a valid award, the law requires the award to specify the place or seat at which it is made. So once the award has been made, there cannot be a situation in which the seat or place is left undetermined, which at least helps in the context of where the section 34 may lie. But I mean, as Gaurav said, there are a lot of times in which seat becomes relevant, even during the arbitration, in which the message is to the tribunal that it's your job now to ensure that there's clarity as to what is the seat of the legal status of the arbitration that you are in charge of. And that will become even more important, especially with the, I mean, I would say problematic omission of Section 42. The reasons for which I think we'll only discover over time. They're not very clear right now.
Right, great. Thanks. Harsh, from London, like from your perspective, like not practicing in India though, but like how do you see this change? Like especially for the as an international lawyer, when because maybe it has a potential of increasing litigation, especially India seated international commercial arbitration. So how do you see that?
Thank you, Dr. Nidhi, and thank you to specifically for organizing this wonderful event. Completely echo what Gauhar and Harshad said. I'll just make one additional point, which Harshad touched on, which is, I think, very pertinent when you look at things through an international lens, and that's the tribunal's duty to determine the seat. And I think I want to emphasize Section 20, Clause 2, where it says shall be determined by the arbitral tribunal. So there is a positive the seat shall be determined by the tribunal. So there is a positive obligation on the tribunal to determine seat. And I think one of the big differences, because I did practice for many years in India before moving to Singapore and then London, is arbitration should operate holistically. It's not just the legislation, it's not the judiciary, but the bar plays a really important part of it as well, and as do arbitrators. So understanding that there is this obligation on the tribunal need to be aware of it. The party should raise it to the tribunal and have that determined at an early stage, as is frankly best practice everywhere in procedural order number 1. The other point, I think, to your original question, Dr. Nidhi, is the scope for litigation, and I really see that in Section 2A, 1 small 2, and for the purpose of generating debate here, do we really need that? Because you've got 2A sub 1 subclause 1, which says where it's been agreed, fine. You've got the one where it's determined by the tribunal, and we've seen how that's a mandatory obligation, and Harshad made the good point that it's necessary for an enforceable award. Do you then need in all other cases? Because that, to me, is where you see the litigation arising.
Mm-hmm.
Because you end up in a situation where people will argue, is this the court that has the pecuniary and territorial jurisdiction? Is this the most convenient forum? Should there be another court? And do you really need that? What is the catch-all that it's trying to cover? Open question. Thank you.
Yeah, well, yeah, that remains that whether we really need this both situations 1 and 2 in other cases. And of course, as we said, if we retain that in other cases, then do we not need to retain also 42? Tariq, maybe you have certain views on that.
Yeah, hi. Thank you, Nidhi, and thank you so much for having me here. I completely agree with the views that have been expressed by the other panelists. Just a couple of quick thoughts. I mean, see, it took us almost 20, 30 years to give clarity to the concept of seat. Started from Valco, interpretation was done, 21 place should be understood as seat. 2 would be where, seat is not defined, tribunal gets the power. I think all those clarifications have now come, all that judicial effort which underwent in giving clarity to the law, all that could have been done if this amendment came earlier. But I think it's a very positive move. Now, why is seat required? Because I think your question was that whether seat in domestic aspect is relevant. The answer is, I think it's absolutely necessary, whether it is domestic or it is international scenario, because the point is that seat is the epicenter of an arbitration, and it establishes the jurisdictional boundaries for that arbitration. Once you have clearly decided on the seat, the issue whether you have Section 42 or it is omitted, I think that becomes irrelevant. The second aspect is, suppose that the seat is not defined. Now the law is clearly saying that, okay, 21 is talking about power of the parties to decide the seat. If parties do not agree, okay, 20 subsection 2 says tribunal will decide. Now, third, of course, only talks about the venue, which is merely a geographical location. Now, my problem that I see in the current drafting of the law is the option 2, which has been given. I don't think it makes any sense. I think this should be completely removed because it is going to create confusion. Because I think 20, the first option itself makes it clear what the intention is. Now, coming to the omission, Section 42, I think, was very important as long as this clarity in Section 20 was not there, because it has played a very important role in addressing certain jurisdictional issues, particularly in cases where cause of action had arisen in different cities or places. So I think given how long it took us to establish clear jurisprudence in India in relation to the seat and the jurisdictional aspect, a thoughtful amendment rather than a complete omission could have helped in streamlining the process to avoid any additional confusion. And very quickly giving you one example how this is going to result into a problem, the option 2 which has been given. Suppose, let's just take example of a domestic arbitration. One party is in Bombay and some transaction happened there, and some part of the cause of action has arisen in Delhi. Now it says that, depending on cause of action or where the contract has been executed, that place will be the seat. 42 actually helped in such situations because 42 said wherever you will file the first application, that court alone shall have the jurisdiction. Now 42 is gone. So, I think the option 2 of 20, if that goes away, then it's fine. It will keep it into check. But 20, option 2 remaining there and 42 not being there is going to be a problem. These are my preliminary thoughts.
But just to say something in continuation to that, I don't know, I may be reading it completely wrong, but I don't think there is an idea to retain both the options. I think it has been proposed as options, maybe in a draft bill, as one of the either will retain.
Absolutely.
Yeah.
Absolutely.
So I think the
No,
second,
therefore, I'm saying if they keep for option 2 and 42 not being there, there is going to be a problem. Because option 2 gives parties option that where cause of action has arisen, that place will become the seat. Now again, parties may say, one may say that Bombay is the seat, the other may say Delhi is the seat, and 42 is not there. Therefore, the option 1 should be retained and option 2 should go away, is what I'm saying.
In case of Section 20, yes. In case of Section 20, definitely, to me also, option 2 does not make much sense. And it was a little surprising in a bill like for an amendment of a section, we have like these two options being given. I haven't seen that before. Good afternoon, ma'am. Justice Mittal has also joined. Ma'am, you are on mute.
Good evening, everybody. Good evening, Nidhi. Sorry for joining late, but I've just taken leave of absence for 10 minutes from a ongoing arbitration,
Okay.
Nidhi gave no notice. She only called me 2 days ago. And I really haven't had a chance to look at your note, etc. But if you'll give me a minute to interrupt, to make some suggestions which this call can debate.
Yeah, I think we can. Okay, ma'am. Yes, let's go ahead.
No, let Tariq complete what you were saying.
Ma'am, I have completed, ma'am. Good afternoon.
Good afternoon. So it's really good to see so many people on this call. I think so many people are interested in the new amendment. And very interestingly, it's surprising that this is what the legislature does. They ignore the 2019 Act and they still talk about the 2015 Act. For instance, when they refer to 12 months, they say 12 months from the date when the arbitrator takes notice. Whereas it should have been 2019, as per the 2019 Act, it should have been 12 months from the date when the pleadings are completed. And there are huge vacuums which they've left, which have led to a lot of controversy in the courts. Nidhi, is it okay with you? I hope I'm not digressing from your plan.
Ma'am, it's bit of a digression, but if you have limited time, maybe we can put up with that.
No, you can ignore me completely. I know you have such experts. I see God.
No, ma'am, please. I think we would want to hear from you also.
Real experts who have much more experience than I do. I'm what should I say, taking baby steps in arbitration.
No, but we still would like to hear from you.
So what I would like to consider is that while we are discussing changes in this legislation, I think we need to look at best examples and follow best practices from across the globe. For instance, Singapore, Mauritius, and I think even Iran has two separate legislations for domestic and international arbitration. And I think this would be very, very necessary and very important. Secondly, the Section 9 post-award should be restricted to the party which has the award in their favor. Otherwise, you'll be giving a bypass to Section 34 and creating a huge problem for the party which has succeeded in the arbitration. The third is the suggestion in the draft bill which says records of the arbitral proceedings be handed over ipso facto to any party. Now, this without any safeguards as a secure soft copy be retained either by the arbitrator or by the court which appointed the tribunal or by some designated authority would be actually can be very suicidal, where a party is dishonest and tampers with the records. So some safeguards in this regard need to be provided. I would also suggest, I've seen this in international arbitration that matters aren't adjourned after cross-examination. Straight after cross-examination of the last witness, you go into final arguments. The tribunal is fresh with the evidence and the parties are also with you on everything, and it really helps in expeditious disposal. Here we tend to do it the way we do it in courts. Evidence goes on forever, then arguments go on forever, and with lots of adjournments thrown in. So the final arguments are spread over even sometimes over 1 year, 1.5 years. I think the draft bill should propose a format of skeletal arguments and the first procedural order. I think that would help bring a lot of clarity and shorten the proceedings greatly. It can make the suggestion, it can propose a model or a format, and also in the first procedural order, it would help if a small summary of what the dispute between the parties are is also added, because that enables you to decide formal applications for discoveries and production of documents, etc. Then another thing which I find the legislation is proposing is the requirement to deposit stamp papers. Now, the moment you do that, that means the tribunal has to disclose the quantum. And, that means you're pre-exposing the award actually. People will become aware of what the award is going to be when you ask the party to deposit the stamp paper. So this needs to be looked into and worded carefully. Either you have 2 stages, pronouncement of the award and a second stage for deposit of the stamp paper. The award would be made available only when the stamp papers are furnished. But requiring the tribunal to tell a party that you have to deposit stamp papers worth a particular amount, you've actually exposed what your award is going to be before having pronounced it. Also, there are several agencies where they have panels of arbitrators, and I see that the organization just appoints these arbitrators. It should, in all fairness, keeping in view party autonomy, the agencies, the authorities should be asked to disclose the panel of arbitrators with their qualifications and experiences so that parties can choose who they want to appoint. So, and also a format of the rules of procedure in ad hoc arbitration could be proposed and suggested, subject to the consent of both the arbitrators as well as the parties. I've also heard a lot of complaints in the work that I've been doing about lawyers who face a lot of difficulty, where the arbitrators were chief justices of the Supreme Court of India or senior judges of the Supreme Court, and the Section 34 goes before a very young, very junior sub-judge or ADJ who may have been appointed by one of these senior judges who are the arbitrators, and they feel very overawed and reluctant to deal with those awards. So perhaps the legislature could consider, this is a very practical aspect and it's a hard reality. Judges are human and they're also products of the society. And, to be able to overcome such biases or such apprehensions of the parties, it would be, the legislature needs to consider whether Section 34 could be before the High Court. They made this suggestion where international awards are concerned, but this could be done here. Now, Section 23 needs to clearly define pleadings, and it must include the counterclaim and a rejoinder where permitted. Section 23 is absolutely opaque as it was in the past. Now, if you see that the proposed Section 29A, capital A, which I just pointed out, it is still referring to the provisions of 2015 ignoring the 2019 amendment 12 months from the date of entering upon the reference does not account for amendment of 2019 at all. So these are a few observations which I made. Rest, I see your questions cover everything, and the experts on this call will deal with them. So if you don't mind, Didi, may I be excused? Much
Yeah,
more
ma'am.
continue with all of you.
Great. Thank you, ma'am. And thanks
And
for covering what we didn't envisage to cover. So I think you have been able
no,
to
no,
raise some
I wish
points.
you'd given me more notice. I would have learned a lot from hearing all the experts and your brilliantly framed questions. But
Right.
a very good initiative by the National Law University, Delhi. As always, you're on in the forefront. And thank you for letting me be part of your discussion, sir.
Thank
Very
you, ma'am.
good. Good evening to everybody. Namaskar.
Thank you, ma'am. Namaskar. Thank you. So, yeah, ma'am has touched upon certain points which I was not part of my plan, but I think it's good, like, because there were a lot of minute issues which I don't think would have been able to cover in 90 minutes. But yeah, of course, I think they are much of a higher practical relevance. So probably that's a good input. Maybe we can come back now to our just to our structure that we were following. And Mehak, I really would want to have your view also on what we were talking about very quickly on 2A, on the idea of introducing seat, and how do you see it?
So look, clarity is always welcome, but I am actually looking at where does this go in terms of my government contracts. That's where I'm looking for maximum clarity, and it doesn't. Government contracts tend to say various things. They would say place, they would say seat, they would say location. They can say anything. So even if this clarity is brought about now, I don't know how it would be taken from a retrospective point of view. And government contracts, again, they're government, in fact, entities are very inflexible as far as changes are concerned. So that's where my apprehension lies. Otherwise, all in all, most definitely a very welcome change.
Okay, thank you. Thank you, ma'am. So I think we can probably somehow have this agreement that, yeah, it's a welcome change. I have a different view, but still, like, it is a welcome change. And I'm entitled to have that view as an academician, probably. So, yeah, we can see on the face of it that it's a welcome change. At least it's bringing in certainty. Ma'am said a very pertinent point. Maybe during the course we can take this up and connecting it to something that most of the jurisdictions, they have separate regimes for domestic and international arbitration. India, we have a same regime. So that was also one of my concerns when I said, do we really need to introduce it in domestic arbitration? So that remains that this idea of like 21E and 42 combination, according to me, probably worked well for the domestic arbitration. But yes, since it was already introduced, so as Tariq rightly said, that it is good to bring it certainty if that was already there and if it was like we were already talking about it. And then, of course, omission of 42, we all agree that if it is like in other cases is there, then that probably needs to be rethought. So I think that's largely about 2A, or definition of court, and also along with section 20. I think this option 1 is a welcome change, which makes a clarification between seat and venue. And then, as I understand, addition of 22, which has always been there. So probably that is just to explain that there can be a distinction between seat and venue. So that has always been the rationale for having specifically venue to make it apart. So that's what there in the model law too, that there is a separate section on 20 clause 2. I think we can move on now, if you all permit, to the next thing that we thought we will be looking again, and which also is a very fundamental change, that is deletion of 9 clause 3. And as we have all seen, 9 clause 3 removes this possibility of approaching the court once the arbitral tribunal is constituted. And 9.3 was interestingly introduced through 2015 amendment. And I think within a period of, let's say, a decade, we are removing it. So I think that remains one very important question as to why are we making this back and forth. And removing 9.3 also will make Indian jurisprudence or Indian law very different from what model law is suggesting, or many other, because other jurisdictions, this possibility to approach the court during continuance of arbitral proceeding is there. So I would want to have your reflections on this deletion of 9 clause 3. So Harsh, maybe I can start with you first to have your reflections on this.
Yes, thank you, Dr. Nidhi. I mean, I agree in that I find this quite surprising. And I think the best way I can explain it is, and if we really look at an international perspective, one of the, we won't get into the reasons for better or worse, but one of the big concerns that international clients have when they're arbitrating in India is the use of guerrilla tactics to derail the arbitration and delay dispute resolution. And you can basically, by deleting 9.3, what happens, if I put it as a question, if there's a tribunal that's constituted, one of the parties wants interim relief, and the other side challenges the arbitrator, even on totally frivolous grounds. If an arbitrator's independence or impartiality is challenged and he can potentially be removed, there's a question mark as to whether he has any jurisdiction to pass any interim orders. And if you don't have 9.3, which operated when the tribunal was not efficacious, you're left with very limited remedies. There are some, arbitral legislations that will allow extraterritorial jurisdiction in terms of passing orders. But even if you had the benefit of that, how do you enforce it in India if everything's in India? If you need an injunction, for example, and the property is situated in India. So for me, I think this is quite a surprising deletion, and I can see a lot of scope for abuse. And if there was proper judicial restraint in exercising 9.3, there's no reason why we should have deleted it.
Okay, great. So, Tariq, maybe I can move on to you, because 9.3 in principle is supposed to be there for promoting institutional arbitration. And you being like really part of a major institution. So I would want to know what are your views on like this 9 clause 3 being removed.
Yeah, so I think a lot will obviously depend on how it is implemented and how effectively the change is going to be. But I think if I go a step behind, because earlier the law was before, during, and after. And one of the issues that I see, because now we are pushing, moving towards the institutional arbitration. So as you know that suppose there is an institution involved in the matter, and beforehand you have the option of going into emergency arbitrator, and you may not have to go for section 9 at all to the court even before the arbitral tribunal is constituted. So I think at least in cases where any institution is involved, there could have been an opportunity under section 9 that even before we don't need to go to 9, because the idea is to ensure that court involvement and intervention is minimal. And I was, in fact, involved in one of the landmark cases when 2015 amendment came on 23rd October. And there was a discussion regarding 9.3, that court shall not entertain an application. And there was even a discussion on 3-4 dates on the word entertain. But the point being this, that earlier, when you say that tribunal is in place, what is the role of the court? And the examples which were cited by some of the leading lawyers was that, look, arbitrator is a creature of an agreement and does not have power over third parties, and therefore arbitrator may not sometimes be able to give any kind of relief, interim relief, which even courts can do. But I think, the intention behind removing 9.3 may be, and, like you rightly said, we are taking a different position than other countries. We are in a way trying to give more teeth to the arbitral tribunal. And in my experience of doing various arbitrations as a counsel, as an arbitrator, and now with an institution, I have not come across any situation where, during the arbitration proceeding, there was an absolute necessary, unless the arbitrator, dies in the proceeding. I'm sure these are extraordinary circumstances, but there is nothing that a tribunal cannot do. And especially if we are pushing and moving towards institutional arbitration, the idea is that institutional rule will always be able to take care of this situation. Maybe they can substitute. For instance, our rules permit appointing, a substitute arbitrator in no time. So I think all the remedies are there with the institutional rules itself. That's what we should be talking about, rather than relying on the courts. That 9.3 is gone, courts should have some leeway. I think it should be seen as a good move. But of course, like you rightly said, and I like Harsh mentioned about the tactics used by the lawyers, and not just in India, I think it's all over the world. But a lot will depend on the implementation.
Great, thank you. Mehak, coming as an in-house counsel, would you have any view on like this is like giving more power, more leeway, more excessive leeway probably to tribunal? Or so
I know I definitely don't think it's excessive leeway. I have been a victim of many delayed tactics being applied by all parties. So I am in favor of reduced intervention by the courts. I think as a foreign conglomerate, it's very important for me to be able to give certainty to my executive or my global management in terms of a process. And when you open so many doors at the same time, I think it's an issue. It gives, like Tariq rightly said, during the arbitration proceedings, there may not be too many situations where I do need to go to court. It would really be prior and sometimes after. So I think I would welcome this as a change. I work in in an industry which is extremely capital intensive. So for me, every single delay matters a lot. So I actually welcome the change of having emergency arbitrators versus going to court for interim relief. Yeah, though I do have one question there that as far as institutes are concerned, of course, our courts do not have the wherewithal to, deal with so much of backlog. We're already suffering, but I think even institutes need to be able to build their capacity in a really short period of time if we are going to go into the emergency arbitration route. They're going to be flooded very soon if this amendment comes about. So that is something that we'll also have to think about simultaneously and very quickly.
yeah, thanks, Mehak. And I think as far as emergency arbitration is concerned, I think we all agree with that was a change which was required to be made because that was also recommended by Shri Krishna High Level Committee, Justice Shri and Shri Krishna Committee. So that I don't think so much is like a matter of discussion, but it was more problematic. That seems to be deletion of 9 clause 3, which like takes away completely the possibility to go to court once the arbitral tribunal is constituted. And Supreme Court recently in ArcelorMittal had tried to like give some stability to the jurisprudence there and to power of the court there in sense of being very restraintful and all.
So look, the thing is,
sorry.
No, that's fine. I think it's a very subjective point of view, and I think everyone comes from their own professional experiences. So that's like I said, I've been a victim too many times, and so for me, it's a welcome change.
Yeah, great. Thank you. Gaur Arshad, I'll come to you very quickly on the same question, like about 9.3, because I think that's a major change. So maybe Gaur first.
So I think there has been a regime of emergency arbitration outside of India. CAG and other institutions already have it. So it's just about implementing it now in our domestic scenario. And when we are borrowing the good things from the West, why not this? And from a practitioner perspective, what I see is that taking away a court's power and giving it to an institution will be a very, very uphill task. And Tariq would agree that today, if I move a Section 9 before a court, it has a different connotation, a different strength in its own self. And when I move it to an institution, I think it'll have a slightly different bearing and different seriousness amongst parties. So I think that's the slight shift we'll have to adopt and adapt ourselves to. But all in all, I think emergency arbitration is not a new concept. It was always there, available to us as a matter of inspiration. And now by way of bringing it in as a statutory regime, I think it's again a welcome move. Whether it will prove to be a welcome move, again, as I said, we'll see. There'll be issues with respect to implementation of it. There'll be some issues whether courts or the legislature when it formalizes this, will there be a discussion on from stakeholders who will obviously have something to say? Today we have been asked to give comments, but at some point it has to be discussed amongst the judiciary whether or not this is a welcome move with respect to seeing this emergency arbitration versus Section 9, which we usually call. So will they be okay about giving up their powers, delegate their powers to an institution? I think that is something which we'll see as an Indian practitioner.
Yeah. Harshit, also also especially 9 clause 3, deletion of 9 clause 3.
Yeah.
Uh,
Well, I mean, I get everything what Mehak said, and it's a very important. Now, I remember in 2015 when the amendment came, I was like a few years into litigation, and there was a lot of excitement around it because it struck a sense of balance between 9 and 17. That your primary route is to go to 17, but just in case 17 is not efficacious, you have a fallback of 9. Now, this balance has been changed because you're saying that there is no fallback available. The way I see it is that, and it's not India alone, globally, there is now an increasing race to the bottom in the sense of saying we promote arbitration, and how do we demonstrate it? By reducing all the avenues in which you could have either a parallel or an appellate recourse to court. And I believe the removal of 9.3 comes from the same sentiment. The Amazon judgment laid the foundation for emergency arbitration. And to the extent that 9A, consistent with 9.3, says that now instead of going to the tribunal, instead of going to the court, you can go to tribunal or emergency arbitration. But keeping in this sentiment in mind, I think when the legislation spoke about emergency arbitration as well, along with 9.3, there were certain aspects where it could have given more clarity. For instance, Amazon was an India-seated SIAC arbitration, but you still have a big vacuum available, and you've had it for many years. What happens to emergency arbitration, which involve Indian parties, Indian subject matter, but it's seated outside? Are those awards enforceable or not? In those kind of situations, having a very clear access to courts, I mean, that one, the parliament hasn't proposed to, or the government hasn't proposed to give an answer to those sort of questions. So it's like good steps have been taken, but I'm not usually a fan of this race to the bottom where you limit access to courts and say everything you go to the arbitration, even without any fallback. But it's a competition. When the government says we want India to be the next Singapore, Hong Kong, this is the kind of step that actually may turn that dream into reality.
Great. Yeah. Thank you, Arshad. I think that really echoes most of us for the sentiment that we really will have to wait and watch. Now, Harsh very rightly said that deletion of 9.3 will raise its own kind of problems. And yeah, for me as an academician, I will say to me doesn't seem like a welcome move, though I really appreciate emergency arbitration's statutory recognition. But there also, as Harshad very rightly pointed out, that we are not talking anything about foreign seated emergency arbitration or foreign seated emergency arbitration awards. So because Amazon also cleared the position about India seated emergency arbitration. So that vacuum remains, and I think we would need maybe something intervention from the judiciary again to be able to tell us more about this. And I personally do share that sentiment very much, that in order to reduce intervention of courts, probably we are also removing the avenues to go to the court where it is most required. So that also has been a feature of Indian arbitration. And I think most important of this is probably, if you'll have time, we'll look more. Vishwanathan committee report suggested this possibility to appeal of rejection of 13.4 and 13.5 applications going to the court, because Indian law is the only law where we say that once your challenge to arbitrator is rejected, you have to wait till the award comes and there is no possibility to approach the court in between. So that is also in the spirit of reducing court intervention.
Yeah.
And Vishwanathan committee suggested to make that amendments to introduce the possibility to go to the court, which has not been accepted. So of course, we're driven very much by reducing court intervention. But I appreciate Harshad's comment as to race to the bottom and to what extent we can go on doing it. I think we all agree we can probably move now to the third, and to me, which is the most important change, which appears to be, is this change in 34, which makes 34 derogable and introduces appellate arbitral tribunal. Once again, the move seems to be twofold objective. One is introducing two-tier arbitration because Centro Trade happened and the Supreme Court said that it is valid. And then the second is, on the face of it, it seems to be that to reduce workload of the courts, because courts are overloaded, so we give more work to institution and institutional arbitration, including not only interim relief, but also the task of setting aside the awards, which I think seems really, really like a very significant and a very big change. Also, once again makes Indian jurisprudence or Indian legal position very different from legal positions in rest of the world. So I think I would really want all views of all of you on that particular point. I'll start with Harsh, like looking at how in your jurisdiction two-tier arbitration or appellate tribunal is seen and how this kind of a situation.
Thank you. I mean, I think there's a practical point here, and this is something that Justice Mittal touched upon. I think in India should, yes, there's an element of borrowing best practices everywhere, but India is so unique. It is so big. There is so much work here that we should think about what works well for India. It's like Americans have their AAA arbitration, and that keeps all the arbitration in America is mostly AAA objective. From that perspective, I think there's something good about this appellate arbitration point of view. I do have one suggestion though, and I'll give the suggestion first before I explain why. I think if you had in 34 in the proviso, if it said provided that where the parties have agreed after the issuance of an arbitral award to take recourse to an appellate tribunal, no application shall lie. And the reason why I talk about that is, firstly, if an arbitration agreement is null or void, or that's one of the bases on which someone wants to challenge Section 34, on what basis is the appellate tribunal going to have jurisdiction? So that same defect that infected the original, or potentially infected the original award, is going to carry through. And then when are you going to litigate it? By adding those words into the proviso, you do away with that problem. And you might argue, well, why will a losing party ever agree? And that's a good point. It might agree because it wants it done faster, particularly when you're looking at international clientele. They'll be like, you know what? I'm happy to take another arbitrators. They'll be more fast, they'll be more professional. I've got more party autonomy, all the good things that we say about arbitrations. Or they might say we want to go to court. And it doesn't necessarily have to be maybe after the award. You could make it more caveated. You could say after the conclusion of the proceedings, or after the hearing, for example. But that to me is the gap that creates a lot of problem. By removing the option and making clear that parties are agreeing to appellate tribunal, you've created scope for massive satellite litigation, particularly because you're not addressing the situation where there is a jurisdictional problem with the original arbitration.
Okay. Tariq, as Mehak also pointed out, that institutions have to pace up for this kind of work. So what is your view for this amendment? Do you think it promotes institutional arbitration, also at the same time engenders more litigation and just adds one more layer to dispute resolution, because then probably 37 stage will become 34 stage for the parties. So that's
You're right, Sunidhi. Firstly, I wouldn't call it a two-tier mechanism, because the reference to Centrotrade, in Centrotrade, there was a different issue when one round of arbitration had to happen in India, and then there was a London. I think ICC was sitting over it. I think this is more like a substitute to 34, like you rightly pointed. That if there is an institution involved, and in any institutional arbitration, then the only problem is, I think there's a sloppy drafting of the law. I think it's a great step. But my only thing is, again, the implementation is going to be a problem for 2-3 reasons, which I'll just briefly tell you. Number one, the terminology is that institutions may. So there's no mandatory, requirement. And of course, nobody was prepared for it. I think, we have all option of scrutiny of awards, where a governing council scrutinizes the award. But that is not in the nature of an appeal. That is only for the purpose of checking the quality of the awards which are being given, so that there is less room for interference by the courts and for setting aside, and they can be easily enforced. Now we have to see whether what will happen to this governing council, or to the ICC court. For instance, ICC awards are scrutinized by the ICC court, and different institutions have their own set of rules, and they have their own ways of scrutinizing. So whether this scrutiny and this appeal, how it's going to play out, that's one thing you have to see. The other thing is we have to also notice that I think the language of the amendment which has been suggested, it says that the procedure which has to be followed by the appellate tribunal will be determined by the Arbitration Council of India. Now, one is that as an institution, I have my own set of rules which have been drafted by the experts, and every institution, be it ICC, CIAC, LCIA, they have their own set of rules to look into this. Now, if Arbitration Council of India is going to determine the procedure, that's my reading, then I don't know how and what will prevail if at all there is a contradiction. Because Arbitration Council of India cannot be, framing the rules for the institutions that this is the procedure you have to follow. That will be like taking the, flexibility from the institutions. So I think it will all depend on how it will play out. But what is good is that now we have an option of not going to court under 34, because the reality, if once we file a 34, we are stuck in it. We don't get to see the color of the money despite the judgments of BCCI and the automatic stay and all. We have come a long way, and I think everything has happened at the right time. But this definitely is a good intention, is good, but everything will depend on the implementation.
Okay. Mehak, coming from a like a conglomerate, corporate conglomerate, how do you see it? This reduces court intervention, yes.
So I think for me, everything is about reduced court intervention. But like Tariq rightly said, the color of the money, that's all that I'm interested in. So if you give me good implementation, I'm more than happy. Anything that reduces the process to being more efficient, and it refrains from becoming a mirror image of litigation, is welcome for me, as long as you show me the color of the money.
Great, thank you. Harshad, I'll come to you. Also, like the point Tariq very rightly said, first there is a conflict between the institution's rules and the rules by Arbitration Council. Second is, as I read it, the word used is appellate tribunal. But then the amendment says that appellate tribunal will only be doing the section 34 thing, setting aside. So it will not, it will be exercising the supervisory jurisdiction, not the not sitting, not in appeal over the
Absolutely, you're right. 37 is separate. You're absolutely right.
Yeah. So I think I should like that point also, like, first of all, what is your view on this change? And then probably what could be done probably to set it right or not.
Well, I mean, as you rightly said, when I first read this amendment, my first thought went to central trade. And I think that was also at the back of the government's mind. But there's a lot more to it. I agree with Tariq that central trade isn't the whole of it.
Yeah.
Where I think the government, and that's why I get puzzled, is what they're trying to have here by this concept of appellate tribunal and even having the council frame the rules for it is something what you see in investor state arbitration under the ICSID convention, where the scrutiny of awards is left to an annulment committee, which would be set up and then regulated, and the procedure would be regulated under the ICSID convention. And in such cases, you have a sort of a check where it's something like an appellate tribunal. You have the grounds for them being defined under the ICSID convention, and it's not a retrial per se. But what you also have along with it is that once the annulment committee has decided on the challenge, then that's over. There is no judicial recourse thereafter. Now, why I say I'm puzzled by it? Because since 1965, ICSID conventions existed, and India has taken part in the framing of the convention. But from the very beginning, despite participating in these discussions, India has been opposed to the ICSID convention. One of the reasons being precisely this, that arbitration, especially in high-value disputes, even at a bare minimum level, they require some element of some judicial supervision, some court. It needn't be Indian court. And that is why till date, despite having done so much rethinking about investment of arbitration approach, India has not ratified the ICSID convention, despite there being 150 plus countries. Meaning India here, the government here proposes to have the annulment mechanism similar to ICSID convention, but not giving it finality because you still have the 37 recourse available. And that's where I start seeing problems coming in, because and Mehak rightly said, at the end of the day, does it help litigants? I'm not sure how much of help it does, because what I see it happening is that, okay, even if litigants prefer in their contracts to have an appellate tribunal, because it may, let's say, be faster than a usual 34 court proceeding, it will never be the end of the litigation, because whatever the appellate tribunal decides, there will be a 37 appeal after it, then there will be an SLP. So it's simply a question of substituting one part of litigation with an appellate arbitral tribunal, but letting the remaining litigation continue. And that's problematic. The second part, and Tariq briefly touched upon it, is it leaves some sort of ambiguity because, subject to correction, the way I read it, the amendment doesn't say that the appellate tribunal necessarily has to be seated in India alone. So if you take inspiration from Central Trade, it leaves open the possibility of parties in their contract agreeing to an appellate tribunal, which let's say is London seated, but it still keeps the 37 door open. Meaning, what happens in a situation where there's an India seated tribunal, followed by an appellate tribunal, let's say seated in London or Singapore, and then is the law proposing that a foreign seated appellate tribunal, or you will have an appeal from that under 37 back to an Indian court. I don't think they fully thought out how this thing will function in existence, and it's more gimmicky to me than actually having. And this is where I take cue from what Justice Mittal said. A lot more could have been done to ensure that the post-award remedies have become efficient. For instance, Mr. Falin Nariman, late Falin Nariman, had said in 2009 in one of his lectures that if you really want to make a difference, the law should be changed to say have 134, let it be to the whatever concern highest court with no further appeals, or the Supreme Court, as is the situation in Switzerland. All your 34 equivalents straight away come to the federal court in Geneva, and then there's no litigation thereafter. These sort of amendments actually are the ones which could make a difference. Everything else, including an appellate tribunal, it looks like progress, but I think it's going to lead to a lot more problems. That's my view.
Thank you. Gaur, I'll come to you. Also will add to it, like if you look at the amendment, it does not really talk anything about like what would the appellate tribunal be composed, who will be like the members, how will we go about like appointing them, issues relating to independence, impartiality. So everything about like appellate tribunal is like kind of left for rules to be made. Yes, of course it says that the rules to be made. So it's like at this current stage, don't you think it's really half-baked? Or
So this is the only change where I would say is not a welcome move at all. And I give you my reasons. First is recognizing 34 as appeal is the biggest trouble, because 34 anyway would have been recognized as a challenge. And as Harshad rightly pointed out, there has to be a full stop to this process some way. By introducing a new process where you are calling it an appeal against an award, making it amenable to reappreciation maybe of evidence, contract, the interpretation, etc. And since there is no rule right now whether or not there'll be a proper hearing, whether it is a statutory appeal, there has to be a notice, a reply has to be called. Because as we practice in Delhi, and Harsha, Tariq, we all have at some point practice in the Delhi High Court. Delhi High Court dismisses or allows 34 on day one also. So I think that factor and and we have achieved it after coming from associate builders till date. That intervention to an award or reappreciation of anything in an award is something that the courts are refraining from. So while we have reached that stage, why is it a necessity now to introduce a new regime where we will see another set of litigation opening up? Of course, again, as I use the word lawyer's paradise, it'll be excellent. We have another tribunal or a council where we will go and practice. But people like Mehak will get affected by all this, because ultimately they're not going to see the color of the money. 34 was never an appeal. It should never have been considered as an appeal. It was a challenge to be decided on day one, whether or not the award is so patently illegal or there is something really worth looking into it. Bringing it within the ambit of an appeal makes it problematic. According to me, this is one change that should not be accepted.
well, I think just to play now the devil's advocate for once, when you all are not accepting it, probably I can speak it to say maybe what is like being suggested is that one is 34 being made derogable, because about Indian jurisdiction that was like doubtful whether parties can opt out of 34 or not, because many countries allow that, many jurisdictions, and in India that position was unclear. So maybe it makes it possible to opt out of 34 regime. And probably, as Hirsch said, that maybe a proviso to that, saying that only when there is like something like 12.5, once the award has come and there is a very clear agreement in favor of going for appellate tribunal and waiving your right to have that award being set aside, probably could be a solution. But in my mind, still the problem remains that is it an appellate tribunal or is it listening to the challenge? Because that's where the whole difference lies.
I think just one more point I wanted to make. Just wanted to clarify. I think we are maybe looking at it in a slightly different way. I think the option has been given to push institutional arbitration, and government wants to give you two options. If you are choosing ad hoc arbitrations, you have no choice, no options of arbitral tribunals, the appellate tribunals that we are calling about 34A.
Yeah.
I think what government is trying to convey, if you go in ad hoc arbitration, if you promote ad hocism, you have no options of going to the appellate tribunal. You only will be subject to 34, which may take its own sweet time. Delhi rightly said by Gohar that is more efficient, but there are many high courts where 34s are pending for almost 6 years, 8 years, and there's no end. Government is promoting institutional arbitration in a way by saying, look, if you choose an institution which provides for such rules or such guidelines or an appellate tribunal which will supervise this award, then you will skip 34 and you will be fast tracked to 37. So it is not for parties to put this appellate tribunal in their agreement. To my mind, it is for the institutions to frame rule, and currently it is already there in the form of a court. Like ICC has a ICC court, we have a governing council. I think that in itself, when the rules will be framed, that will be left to the institutions how they want this award to be scrutinized, or the so-called the terminology, the appellate tribunal will look up. Not for the parties, it will be for the institutions. That's what my feeling is.
Yeah, I think that is what it seems to be, that it is, and that's how it is being projected, that it is like within a particular aim of promoting institutional arbitration. And once you're a part of an institution, then you give up your right on challenging 34, which I think, I'll not search this further here, but which I think has its own problem, that whether it really promotes institutional arbitration, because if you restrict my chances to go to court with an award, so it's like double-edged sword, right? It's not necessarily promotes institutional arbitration, because it puts a very important restraint. And as we have seen in case of maybe not so for institution, but at least for ad hoc, like court comes as a rescuer in many cases. So this that also remains there. So I think, yeah, so largely we all agree that it seems like a mixed change, not so welcome, unless it becomes very, very clear as to how this appellate arbitral is going to work. So we need more clarity on that as to how this mechanism is going to work. So maybe to that extent of giving a choice of making Section 34 derogable probably is good. But then how do we work out that choice? I think that there a lot remains to be done. So it's definitely going to create confusion in the coming years by the time it becomes clear. So I really like Paul's expression, which I also use often, lawyer's paradise. So it's like probably, yeah, that is there. I think we have time, so we can now take up 2-3 more issues. One was very much in my mind was 11.6a, because that was already proposed in 2019 and then it was not notified. It was kept in limbo for a long time because probably it was not clear as to what will be the role of the court at the stage of appointment of arbitrators, and can we make court simply the post office, like that everything has to be done by now arbitration council. So now this amendment once again proposes, seems that 11.6, if it is like everything is notified and if it comes into effect, that 11.6a will be deleted and there would be practically no role of, if I understand it correctly, and I may be wrong also, that there would be no role of court at that stage of appointment of arbitrators. So I think I'll want to ask Harshit first, like how do you see this as like role of the courts vis-a-vis at the pre-arbitral stage, if you can call it like that? Yeah.
So thank you, because Section 11 and generally appointment proceedings in India is one of my favorite issues. And I think the genesis of this goes back to the tussle that started with Konkan Railways and Patel Engineering. Because we always, if we look at in most cases where such issues came, the government's argument has always been that the courts aren't meant to perform a judicial role. It's not meant to be the first situation at which the courts will decide some question of jurisdiction. It is meant to be, the terminology used in Konkan Railways was, it is meant to be an administrative role or like a post box office. The courts initially clearly did. And even right now, you see, the courts don't see it that way. And that is why in 2015, when 11.6a first came, It was an improvement on the existing jurisprudence in that it said, okay, we're not saying that the court's role is that pure mechanical, but the court will only look at the existence of the arbitration agreement and nothing else. So it was like a barter that was happening in real time between the government or the parliament in that case and the court, where the court saw their role as Section 11 as much broader than what the government parliament wanted. The 2015 barter clearly did not work because even with this narrow window of existence of arbitration agreement, we had a series of judgments from Supreme Court itself expanding. I mean, some of the things that were said actually would shock your conscience as to what is meant by existence of an arbitration agreement, and then shoehorning other issues into that little wriggle room they had. The way I see this amendment now is that the government is saying, okay, enough is enough. Whatever little wriggle room we may be giving to courts, the courts find a way of expanding that to look into certain jurisdictional issues, even at the stage of appointment the arbitrator. The purpose of removing this 1116A as it stands right now is to essentially say there is no wriggle room. And that's consistent with how courts also in different contexts have recognized that India now recognizes the negative effect of competence, which means that the first place where any and every jurisdictional objection is to be raised is the tribunal. And interestingly, their amendments have also been proposed to Section 16, which now introduces a presumption in favor of bifurcation, another area in which tribunals in India don't do actually themselves proud. They're saying you will now no longer go to a Section 11 proceeding thinking jurisdictional objections can be raised there. There is no wriggle room. You raise it before the tribunal under Section 16, and the tribunal, as a matter of norm, will have to decide within 30 days those jurisdictional objections. Meaning it's not leaving parties remedyless, but it's actually trying to create a machinery where tribunals will be the first one to hear the jurisdictional objection and decide them in timelines which are, if they are implemented in both letter and spirit, would be even more efficient that you see in so many other jurisdictions. Of course, and then the tribunal thinks that bifurcation is not possible, they need more time, then they have to pass a reasoned order for that under Section 16 to say why we're joining these objections to merit. So I applaud the spirit and the context of this particular amendment, because this is one area where I'd say the government has waited and tried to find a balanced solution, but it's saying, okay, we can't trust the courts enough now in a Section 11 proceeding. That's bluntly put is the case.
Okay, great. Thank you. Harsh, I think once again, it will make like India probably a slightly different legal position where the court will have no role whatsoever in appointment of arbitrators. And of course, Section 11 situation comes in when parties are not able to agree on an arbitrator. And its larger impact is on ad hoc arbitrations. So once again, it's like for institutional arbitration, probably the impact is less. So what is your perception towards this deletion of 11.6a? What kind of role can we retain or should we retain for courts?
I mean, I think that's a really interesting question. As you said, this is really a very uniquely Indian problem. I think for better or for worse, this amendment in the long run is going to, for whatever reason it's been put in there, I think it should make practitioners realize that this is not something worth fighting over. And coupled with the boost in institutional arbitration, I think if there is a general recognition among litigants and the arbitration bar, if I can use the term, that we really shouldn't be fighting over agreeing people who will decide the dispute. The actual dispute should be decided, not who is going to decide it. And I think this amendment helps in that process, because that's one big problem with arbitration in India is it just takes so long to get the ball rolling and get to the merits of it, because that's what every client wants. They want the dispute decided, or they want to understand through the process of the dispute, actually, maybe my case is not as good as I thought and I should think about settling. They want to be able to make their commercial decisions. And you can't do that if you've not got off the starting blocks.
Right, great. Tariq, as Harshad said that we had this problem of court ever expanding its jurisdiction, no matter whether in 2015 amendment, it was said that shouldn't be doing it. We have Vidya Rolia, we have like all those judgments. Still, we had parallel judgments where the court went on expanding its jurisdiction. So you, especially belonging to an institutional arbitration an institutional arbitrate institution, and also like having been in practice. So how do you see that? How do you perceive Indian judiciary might respond to this completely, this power being taken away to play a role in the stage of appointment of arbitrators?
See, Nidhi, firstly, in India, unfortunately, the problem has been, and that's been my experience as a lawyer, and I'm sure my colleagues Gohar and Harshad and others who practiced will agree that, the arbitration clause itself become the issue. Forget about the main dispute, and that itself takes about a year and a half. It's easy to drag on the issue to go for arbitration itself. And to my mind, it was never supposed to be the intention of the legislature to leave this power with the court under Section 11. That's why we had a series of judgment, administrative power or judicial power. And the reference in 11.6 regarding the institutions will be acknowledged by the high courts, and they will be giving them the power to appoint. Now, if you look at any progressive jurisdiction, which is a pro-arbitration jurisdiction, I mean, I've not practiced as much as some of my colleagues who are present here, but I would love to be, enlightened. If somebody can tell me that any arbitration pro-jurisdiction which has this practice of going to court for appointment of arbitrator, that's number one. Number two, most of the arbitrations that are done in all progressive and developed jurisdictions are all institutional. The idea behind doing all these things is to reduce court intervention, to push institutional arbitration. That government is telling you, go to institutions, institutions will do all the job for you. We are going to bring Arbitration Council of India, which will accredit these institutions. And then there may be some places where such recognized institutions may not be there. The amendment, in fact, takes care of that also. That in such places, the Chief Justice will be maintaining a panel, and then they also will be treated as an institution itself. You should read it. There are a series of, I was just going through it briefly. So I think it's a great move, welcome move. The time we spend, like Mehak was rightly pointing, as business, I just want to see the color of my money. I want to see India as a place where disputes are being resolved efficiently. If you don't, give these kind of options to the parties that, okay, institutions will appoint in a week's time. The same thing you can get from court maybe after a year, maybe after 2 years. Delhi is one exception, but many courts really are not appointing arbitrators. I don't want to name the states, but I've seen the report being an institution. There was some Section 11 pending for more than 4 years. So that's the situation. And I think in light of these situations, I think it's a great move.
Yeah, great. Mehak?
So I definitely come in that list, Tariq. I have had Section 11 pending for over 3 years. So a lot of the times what happens is that I'm forced to take a decision to try and settle the matter because I haven't been able to even appoint an arbitrator in India. Also with the perspective that it puts some sort of a pressure on government entities. So typically what happens is government entities come with this mindset. They actually have no appreciation for the arbitration process and what it's supposed to be, or that it's supposed to finish in a certain timeline. They internally, of course, not in writing, but they internally have this mandate that they're not going to settle or relent, even if the award is in the favor of the other party. They have to go up to the Supreme Court. So along all the steps that you have, how much ever they can procrastinate, they will, including the Section 11. So at least this is one minor step in between, which gives them a timeline that they need to stick to.
Yeah, okay, great. So Gohar, will you echo the same, that it's like...
I have a slightly different view. Of course, it's a good move that the 11 jurisdiction appointment, and as Tariq pointed out, none of the foreign jurisdictions have this provision of going to court and seek appointment. I think it's a positive move again, but I have a slightly different view when Harshad was talking about various judgments. Recently, SBI versus Krish, Supreme Court, has taken away all the reasons where 11 should interfere. There should be interference at this stage of 11 or not, whether or not a matter should be sent to arbitration or not. I think Krish spinning has actually closed every avenue of any objection to referral of a dispute to arbitration. I think we've reached there. But now going to an institution and starting that process all over again, I don't know how it will pan out, and Tariq will be best placed to suggest and comment on it. But I think we have reached a point in 11 where we have taken away, we have seen NN Global stamping issue, go to arbitration, signature issue, go to arbitration. Anything to do, and courts, I should not use the word, but actually they have tried to become a postman or a post service for the purpose of referral to the disputes to arbitration, reducing the time. But as again pointed out by Tariq, Mehak, that there are some courts where matters in Section 11 are pending for 3-4 years. Unfortunately, I am also having a few of such matters, and we'll not name the high courts. Delhi and Supreme Court being exceptions, I think this is something which is required with that slight bit of interpretation, a slight bit of thing in our mind that Supreme Court is definitely trying to bring a sense of seriousness towards referral to arbitration.
Well, yeah, Section 11 applications being pending for a long time has been a malaise that India has been dealing with. And I would just like to say that even like we saw that after 11.6, 11.6a, another way of making the applications pending was like fighting over which is whether the poorly drafted clauses is a norm. It's like it's not an exception. So the idea whether the chosen place is a venue or a seat, so which is the appropriate forum to file Section 11 or Section 9. So we have seen like protracted legal battles on that too. But yeah, I think we will all agree on this that 11.6a is probably removal of 11.6a for institutional arbitration is a good move. Of course, I think it will stay for ad hoc arbitration. I think that remains unclear that if we remove 11.6a, then what will happen in case of ad hoc arbitrations? So maybe I haven't read something properly, but it seems to me that if we are maintaining both ad hoc and institutional, and if we remove 11.6a, so then how will it work in cases of ad hoc arbitration? To me, that remains unclear. We have some time, and I think before we just take a few questions, I also would want a very quick reflection on this Arbitration Council of India. There has been like a major criticism that it's very government dominated, and it's like government is one of the important parties in most of the disputes, and then this ACI comes, which seems like a government body. And like if we just see the constitution which is being proposed in this bill, it is like all the representatives are, I haven't gone through it very carefully, so I may be wrong here, but all the representatives seem to be like really coming from the government. So to what extent we see this ACI needs to be like more independent, or something which needs to be done with reference to. Harshad, I'll start with you, very quick round. Yeah.
Well, I mean, I agree with your characterization. The way I see it is, I think this overall, the entire set of amendments has a twofold aim. One is to push the country away from ad hoc into institutional arbitration, which is good. The second is that the entire framework of institutional arbitration in India is right now very scattered. You have, for different regions, you have a lot of arbitral institutions. You have some old ones, some new ones. The way I see it, that there is an attempt by the government to not bring them under one umbrella, but create a regulator for arbitral institutions, bring in some kind of consistency. All that's fine, but bring in some sort of government regulation in terms of prescribing the standards, in terms of having an accreditation of some sort of process, which I have certain doubts over, because I mean, the entire foundation of arbitration is free market and capitalism. We may have opinions about it, but arbitration is synonymous with that. This is a way of trying to say that we're going to have a free market capitalism kind of dispute resolution framework, but take away its freeness or curtail its freeness by imposing a regulator, which is not very common even globally. So, and that is what scares me, because it's unprecedented, and because it's state intervention to regulate what essentially should be a free market activity. Maybe it goes well and all these concerns prove to be exaggerated, but much hasn't happened involving the Indian government's regulation that fills you with optimism, and that's where my concerns and my suspicions come from.
Great, thanks. Tariq, very quickly to you, because it's like, as far as I know and read, it was said that when India is introducing this arbitration council, it was following a Singapore model, and it was trying to follow the model that is there in SIAC. So how do you see this?
So I think, especially about the Arbitration Council of India, I strongly feel that it will completely depend on the functioning and how the the office bearers will look at the whole thing. Because Arbitration Council of India is only going to be a regulator. It's not going to be an institution itself. And Harshad was mentioning rightly that it's currently very scattered, and some kind of uniformity in the standard is required, because I see that a lot of people, some people who don't even have an infrastructure, or some people who don't even have any proper dedicated staff or specialized rules, and they're calling themselves as an arbitral institution or a mediation institution, and they are into the commercial exploitation of mediation and arbitration. So I think to that extent, we need a regulator in a country like India. May not be necessary for a lot of countries, but since India is a big country, and to ensure that people understand which are the right institutions. So if the Arbitration Council of India performs its duties in the right manner, which is that to take measures which are necessary to promote and encourage arbitration, and some kind of frame, some kind of policy or guidelines, and some criteria for recognizing these institutions, as long as they are fair, they are independent, and they are having some basic criteria like institution should have an infrastructure, should have two people, or leader of the institution should have some reputation, and some international rules, etc., etc. Some basic criteria has to come out, so that not everybody should start calling them as an institution. I think that to that extent it is very important. The other thing that I feel that good change in this particular amendment that has been brought in earlier, I think the qualification for being the chairperson was being a judge, a retired judge. I think that qualification has gone. So, people who are experts in the field can now, and with a good integrity, can become the chairperson. I think that's a very good move, and that shows more confidence in the whole idea of composition of the council.
Great. Harsh, once again, it's a very unique Indian position that you need a regulator for something which is market-based. So how would you react to this?
Yeah, I mean, very briefly, I agree with Harshad. I don't think that this is the devil will be in the detail, but there are a number of things about it that, for me, give rise to concern. And if we think long term, particularly if you sort of want to open up the legal market to foreign law firms and you want to start having international arbitrations in India, that's going to be a big sort of cause for hesitation. Particularly, for example, if you look at something like it's supposed to lay down a model code of conduct for arbitrators. Is that going to be binding on, let's say, an arbitrator appointed by the ICC practicing as an arbitrator in Indian seated arbitration? And what happens if one party alleges it's breached? Is this arbitrator going to be hauled up before the Indian courts? The market will weed itself out. You'll get the good institutions rising to the top, particularly long term when the Indian legal sector opens up a bit more. So I personally don't think long term, more internationally, this level of regulation is going to be well received.
Okay, great. Very, very quickly, once again, because this introduces red tapeism, but at the same time, it fulfills the need of some regulation, which is a very typical Indian requirement. So you perceive this as an essential, necessary evil, maybe, or differently?
Maybe a necessary evil then. Actually, the question out there, I mean, I don't know how, I think it should be possible. So in my experience, what typically happens is when I'm trying to appoint an arbitrator, or say like I said, my field is very technical, so I would like to appoint technical experts. But my problem over there is that they may not be qualified arbitrators, or they may not be familiar with the process of arbitration, or they may not know how to write an award. So that is the problem that I face. So, and I don't want to go to judges because they will not be familiar with the technicality of the matter, or they will not be able to appreciate that. So if this council can bring about a process which can accredit arbitrators and basically certify that they've gone through this formal training, which certifies them as arbitrators per se, would help a lot. So, and also I know and appreciate the fact that a lot of institutes are doing that right now, but I think they have their own they have their own courses and how they kind of formulate what they need to in terms of their sessions. So there needs to be some sort of uniformity in terms of what is being taught. So for example, all advocates are supposed to be registered, right, with the Bar Council, whether it's state or India or whatever. So I think something like that for arbitrators is important so that there is some sort of qualitative factor when they're appointed. So if the council can bring about that, it would be great.
Yeah, in fact, just one quick point I wanted to add, Nidhi, sorry. So same requirement you have for mediation because the quality of mediators and quality of arbitrators is mandatory. Unfortunately, for arbitration, we don't see a lot of trainings, but you see CMC in London, SIMI in Singapore. They're all regulating body for quality of the trainings which is being imparted. So today, if I just start a new institution and I say High Court of Telangana should accredit and recognize me as an institution, and I will appoint all the arbitrators. Now, the arbitrators that I'm appointing, there's no criteria for me being an institution. I can appoint any Tom and Harry who has no clue. And that's the quality of service I'm providing because I'll say it's a free market. The second aspect is the quality of training. I start, selling these kind of certificates for arbitration trainings and mediation training, and everybody's becoming a mediator and arbitrator. So I think that regulation to some extent is definitely necessary and it's happening worldwide.
Great. Gaur, last word from you on this, whether it is actually a necessary evil or what's your view on ACI?
No, I think as a mentorship, if you see it as a guide who will just look after the processes and somebody who will pave the way if there is any problem. I think if you look at it from that perspective, it is fine. If there's going to be intervention or as we say in the law firm dictionary, micromanagement of issues with respect to arbitration, then it becomes a problem. So basically, we definitely need one body which regulates things, but also we need that body to let things happen itself. It cannot be that the body start calling up Tariq and tells him how to lay down the rules for training of an arbitrator. The institution should have its own power, its own ways of looking at how training should be. And I think if that is the intent, I don't see it from what we see right now. But the intent should be only to just monitor and be a guide, and then leave the processes to an autopilot mode. I think that is exactly what it should do.
Okay. I think if I can use a metaphor, maybe not a very good metaphor, but it's like if it acts like an intelligent parent who allows children who's like enough autonomy to the institution without controlling, probably that's what we expect from this regulator. Correct. That they just observe from a distance and intervene when there is some essential correction is needed. Otherwise, let the growth happen. Although we have run beyond the time, but if you all permit, we'll just like to take one or two questions if there are any. So Tarun, if there are any one or two very important questions, probably we can take them.
Yes, Vedant, we have questions, right? Please ask.
We'll just take two because you're already running late.
We'll also open the chat box in the meanwhile.
Yeah.
Yes. Yeah. So good evening, everyone. So I had two quick questions. I needed to get your perspective on the implications of two changes. First is in section 30, where the arbitral award that has been substituted by a mediated settlement. What do you think about that? What is the implication of that? And secondly, with respect to section 34, we discussed a lot on two-tier arbitration, but there are certain slight changes that they have made, wherein with respect to the grounds of review under 34, earlier there used to be a section. So earlier they used to have 34(2)(a), which was with respect to the party making an application and establishing on the basis of the record. And then there was B, which had the code finds the following, or the code finds that. Now in the new bill, that the code finds that has been removed, and both those categories are essentially the party establishing that. So what do you think is the implication of that? So these two quick questions. Thank you.
Anyone, I think anyone.
The first question I can answer if nobody else.
Yes, please. Yeah.
So I think the question pertains to section 30, subsection 2, which talks about, previously the law was that if the arbitrator sees any kind of settlement happening, then it was converted into, award on consent terms. And we used to enforce it as a consent award. I think the new amendment is now proposing that we will treat this matter which has been settled in arbitration as a mediation settlement, and we'll be enforcing it as a mediation settlement under the Mediation Act.
mediation.
So I think it's a problem because, and I think it's a problem for two reasons. Firstly, if you look at, the enforceability of a mediation settlement, it's a problem at the moment. Mediation Act has been there in the country for more than a year, but nothing has been notified yet. So I think it's just a paper tiger at the moment. And if you compare the enforceability of an arbitral award on consent terms versus a settlement agreement in mediation, of course, the arbitration award on consent terms is enforceable in a proper manner, and it's more robust than enforcing it under the provisions of the Mediation Act, which even have not been till now notified. So I definitely see this as a big problem.
And I'll just
And
add,
internationally also. Yes.
I just want to add on to what Tariq rightly pointed out in the comparison between the consent award and the mediated settlement. Section 28 of the Mediation Act, proposed act, talks about a challenge. So we're not stopping at any point. So I think consent award will have more sanctity in terms of implementation is what we see right now. And since we are not seeing any light at the end of the tunnel for mediation, I think that is a very, very different parallel regime which is going on. And I think still consent awards are going to be a bit more seriously taken by courts in terms of enforcement. And ultimately, everyone is looking for enforcement.
Yeah, great. Thank you. And the second
Sorry, I
part,
just need to drop off. So I'll just quickly say one last
yes,
observation and also say thank you to everyone for organizing this really thought-provoking discussion. But I just want to echo the point Tariq made about international enforceability under New York Convention for an arbitral award. That is critical, and that's something that the amendment obviously does away with. So thank you once again for your time, everyone. It was really a pleasure, and hope everyone enjoys the rest of your day. Thank you.
thank you, Harsh. Thanks for joining.
you.
Yeah, we'll
Thank
just
you,
take
Harsh.
one more minute. So Harshad, maybe if you could respond to Vedant's second question, that is a long one, or maybe we can just drop it also. You're all running out of time. Yeah.
No, I'll try to be brief. That's the question I wanted to respond. And I think, as Vedant rightly pointed out, there was a distinction between the two kinds of objections you could have raised. In the second bucket, which has now been done away, used to lie public policy and arbitrability. And the entire point of that section 2AB or whatever it was being framed in a way was that it wasn't a party-centric, because public policy and arbitrability are so important to a country's own legal system as to what can go for arbitration and what kind of awards are okay. Those kind of objections under the earlier regime, or the existing regime rather, is irrelevant of whether a party raises them, irrelevant of whether even a party raised it during the arbitration, but the onus was on the court or the judge to decide whether there was any public policy violation. Now, given the fact that the role of the judge itself has been made derogable, meaning you can very well have an appellate arbitral tribunal, it's not a move that I welcome, but it's consistent because the proposed amendments change the nature of a 34, what it's supposed to do, and that instead of a 34 judge, you could actually very well have a 34 appellate tribunal, meaning it is now an inherently party-driven process. At least it's consistent with that therefore, if you have an appellate tribunal, it will only decide objections that have been raised by a challenging party. And if a challenging party doesn't raise a public policy exception, now it's not for the court or the appellate tribunal to go into it at that stage. That's my understanding.
Great. I think we can stop here because it's already 6:11 and it's like really overshot the time. Yeah, the amendment has, I think, as I said, there are many more issues which will probably require 2-3 such webinars more, but we don't have time. So many thanks for joining on such a short notice. Yes, Justice Geeta Mittal told me I shouldn't be calling on such short notice, but I didn't have option considering that Diwali and 3rd November. But I'm really happy that it was possible to put it through. To put it together, and you all agreed to participate. So I think, Tarun, we can just end it here. Maybe you can just say a few words and then we end. Yeah.
Yes, that's it for all the questions. I think if participants have more questions, they can email us to us, and then we can mail them back to the speakers for resolving all the queries. Vedant, you can give the closing remarks.
Yeah, thank you, Tarun. So good evening, everyone. On behalf of the Center for Alternate Dispute Resolution at National Law University Delhi, it is my honor to express sincere gratitude to each one of you for joining us today for this webinar on the proposed amendments to the Arbitration and Conciliation Act 1996. First, a special thanks to our esteemed panelists who brought an exceptional depth of knowledge to this critical topic. Your insights into the proposed changes, especially those aimed at expediting India's arbitration process and improving its role, are welcome. Our appreciation also goes to Dr. Nidhi Gupta, whose organization and dedication brought this event to life, and to Mr. Gauhar Mirza for putting everything together on such short notice. Thank you both for your exceptional contributions. Today's sessions has allowed us to consider both the merits and the pitfalls of these proposed changes. While the amendments appear ambitious in promoting India as a more favorable seat for arbitration, some concerns remain, as highlighted by our speakers. I would also like to acknowledge our organizing team and technical support, whose efforts behind the scenes have made this event more thought-provoking as to the extent possible. Finally, to our attendees, your participation is also welcome, and we are thankful for the same. As these amendments progress, we hope this conversation will fuel ongoing discussion in our legal community, encouraging us to advocate for frameworks that genuinely enhance India's arbitration ecosystem. Thank you once again, and we look forward to more such enriching discourses. Have a great day ahead.
Great. Thank you. Thanks a lot. Thanks, Gauhar.
Thank you so
Very
much,
good.
everyone.
Thank you.
Thanks,
Thank you so
thanks,
much,
Mehak.
everyone. Thank you.
Thank
Thank
you.
you so
Thank
much.
Good day.
Thank you.